Here we go. Okay. So good afternoon. My name is Emily Belanger with the Louisiana State Bar Association. Welcome to our Law Talks virtual workshop series. Today's Law Talk is on workers' compensation. We have attorney Amber Sheppard with us today. She's at Pew Ricardo, and she'll be presenting on this very important topic. Before we get started, I need to go over a few important reminders. Amber, could you switch? Yep, perfect. First, the presentation is being live streamed. Questions will be taken at the end if time permits, and answered live. If you're watching at a library, you may walk up to the computer to ask or submit your questions to the library staff. If you are watching via Zoom, please use the Q&A section. And if you are watching via Facebook, please submit questions in the comment section. Please remember that all comments are public and visible during and after the presentation. Finally, please keep your questions general and not case specific. The attorney can provide information about the law and legal processes, but cannot give advice on individual cases. Next slide, please. Please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Civil Legal Navigator. The link is here. The LCA's inclusion on the program is not to be deemed a statement or endorsement of the views expressed therein by the LCA or any member of the LCA. Speakers on LCA programs are carefully selected for their knowledge, but neither the LCA nor the speaker warrant that the presentations or materials are free of errors or will continue to be accurate. Statements in the presentations and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LCA, its sections, or committees. Views expressed are those of the authors and contributors only. So as I mentioned, our presenter today is Amber Sheppard, who has a lot of experience with workers' compensation issues, and we are excited to let her get started with her law talk.
Okay, we're just going to jump into it. I have to tell you about me. I have to tell you about Tubbs, and then I have to tell you about workers' comp. Just so y'all know, if I'm looking like side to side, it's because my camera is here, my screen is there, and my dog is on the other side. So, I may get distracted. I'm just kidding. Okay, jumping into it. I'm an associate here at Pew Ricardo in Louisiana. I'm licensed in Louisiana and Mississippi, but we're only talking about Louisiana today. Just a little bit of my background. I've done business litigation and I've been general business counsel for over a decade. Before I was here at Pew, I did personal injury and workers' comp on the injured person side. So I'm coming at this presentation having handled both sides. We call it the both sides of the V, in the case it's like so-and-so versus so-and-so. Anyway, if you can't tell, you already have. I try to make this as fun as possible. It's not a fun topic. Clearly, you're hurt or an employee's hurt and you're here wanting to get some more information. But I try to keep it light. You will see a lot of photographs of my dog. Doesn't mean that I'm making light of the situation. I'm just trying to keep y'all's attention because it's legal stuff and it's not fun and it can be boring. So I try not to be boring. And my life motto is be fierce and kind because I think you can be a strong advocate for yourself, for your clients, and for your community, but you don't have to be a jerk when you're doing it. I've watched The Simpsons in its entirety, and there's like 36 seasons at this point, at least 6 times. Can you tell I'm autistic? I am. I am. Thank you so much for noticing. But anyway, this is my contact information, but I'm not your lawyer. Okay. Now this is the star of this presentation, I promise. Tubbs. Okay, Tubbs has her own page. You're gonna get sick of Tubbs throughout this presentation. It's fine. Tubbs and I have been a team for 8 years. It's ridiculous. We're both very old. We have done talks for access to justice and law talks a lot. I think this may be our 8th presentation. We love it. We've done service dogs. We've done family law because I used to do family law as well. Estate planning. We've done a whole bunch of stuff, but I love to do them with my best pal Tubbs because I like to make the law accessible. Not just because this is the access to justice project, but I really truly do mean that. I like to make complex legal stuff easy to understand. And I talk with my hands a lot. But anyway, Tubbs is 9. She has her own coloring book. She's the first dog in St. Tammany Parish Therapy program. She is a beautiful angel. Okay. The firm I'm at, y'all are like, whatever, Amber, just get to the meat and potatoes. I still have to. They're the ones that like allow me to do this, right? So thank you to the firm. Their motto is big firm character, small firm attention. We've got clients from local in Louisiana. We have international and national brands as well. Whatever, it's fine. I know we mentioned it. I mentioned it. We, as in Amber and Tubbs, the team. I am autistic, so I'm neurodiverse. You can tell already, I'm sure. But I did my best to make the presentation as accessible as possible to as most people as possible. So we've got some bold stuff in there. We've got some white background and everything because I take access to justice and information seriously. I'm also the American Bar Association Diversity Fellow for this year. Anyway, so let's get into it. I told you I was funny. I didn't lie. Okay, look at this picture that I used. Isn't it beautiful? It's like smushed, so I look even thicker than I am. But that's fine. That's fine. All jokes and opinions are my own. Okay, they're not indicative of the opinions of my employer, the Bar Association, which Emily gave that beautiful speech at the beginning. My clients, anyone associated with me, or even Tubbs. Okay, you can see in this picture she's already trying to leave. Okay, she doesn't even care. She's like, Mom, let's not talk about this anymore. You're ridiculous. Okay. Now let's talk about workers' comp, okay? I am here to make it as simplified as I can with Tubbs, and yes, that is her laptop. Do not tell her it does not work. I don't think she would understand, but that's okay. All right, so we're gonna talk about what is workers' comp in Louisiana, who qualifies for it, how do you start a claim, what that process looks like, how do you figure out benefits, and I hate to break it to y'all, but there's math involved, but it's okay, we break it down. And I'm just being funny, I'm terrible, I'm really terrible at math, so I will say that a lot throughout this presentation. What can employers or businesses who have a worker that has filed, what can you do? And then at the end, there's going to be forms and resources, direct links to that you can access. And again, we're going to be going through a lot of information here. Don't think that you have to like hurry and write down or dictate everything all at once. This will live on the Facebook page for lawyers and libraries. So you can go back and you can access it later. You can even mute it if you don't want to hear my accent. You can mute it, okay? All right, so I want to make this clear. Workers' comp is meant to be able for the injured person or the business to handle the claim process yourself. Okay, so I'm going to be going at this as if you are self-represented, you don't have a lawyer. But no, obviously, lawyers exist that practice this on both sides of the V. There are lawyers to help. There are resources. We have that link at the end, including Modest Means Directory. as well in self-help forms, but it's very workers' compensation itself and the forms and the access to it is very, very I'm gonna call it open source. You can get it from direct websites and you don't have to worry about paying for the forms or doing anything. You could do it yourself. Okay, so dog to our tubs. Okay, what is workers' comp? Now I could have made this presentation where every time you see LARS, that's the statute. Okay, that's the law, the code. I could have just listed out the big blocks of the law. That doesn't mean anything. I need to explain it. Okay. So I do have in here references to where you can go find it if you'd like to look up the actual wording. And sometimes I will have the wording, but if you need it throughout this presentation, you will find the codes. And this is 2026. So this is what the codes are as of today. Okay. So the purpose of workers' comp, okay, and this is like the overall theory, the practice of it, is to provide timely, if you're injured, you're like, really, Amber? But to provide timely medical care and wage replacement for the injured person who has been injured on the job. That's the goal. That's the overarching goal is you get wage benefits and medical benefits if you prove that you were hurt on the job. We'll talk about that. It is the exclusive remedy if you were hurt on the job in Louisiana. Now, you're like, Amber, I see a little asterisk there. Why do you have an asterisk next to exclusive? I'm not going to dive into that, but there are some things that if you get hurt on the job that, let's say it was an intentional act by the employer to hurt you. I mean, it's like egregious. It is crazy. Like he came over and he hit you with a baseball bat or he cut your brakes on your car. Like I'm being like a little dramatic, but like it's that kind of stuff. You could have a personal injury claim on top of workers' comp, but we're going to simplify this. I would say 9 out of 10 times, 99 out of 100 times, your exclusive one remedy, the only thing that you can go after is workers' comp. And the reason for that is that the goal is that if you're hurt, you don't have to go through this big long process. If you're hurt at work, I should say, you don't have to go through this huge long process. You can get your wage benefits. You can get medical benefits from your employer. That's the goal. Okay, that's the goal. So anyway, so like the reason you can see it on here, employees trade their right to sue, so personal injury stuff, for guaranteed benefits. And I put an asterisk next to guaranteed because again, you have to have an injury, you have to prove it, and all that stuff. But for the most part, we're just acting on the assumption here that you're injured. I want my hair down. I'm autistic, so you're gonna see me playing with my hair a lot, and it's gonna be going up, it's gonna be going down. Just bear with me here. And then on the flip side of that, employers trade fault-based defenses for limited liability, meaning medical benefits, wage benefits, and then we'll talk about supplemental earnings. I know you're like, Amber, you said you were gonna explain this. We are. I just gotta do the overview. Okay, so who does workers' comp apply to in Louisiana? Not Yoda. I'm sorry, I don't own the trademark to Yoda. I'm sorry. Tubbs as a little green man with special forces or abilities. I'm just kidding. Okay, so who does it apply to? Employees. Okay, like if you work for someone, you're an employee. You have a contract, you're an employee. With some exceptions here, okay? Subcontractors. So if you work for someone else who has a contract with someone else and you get hurt, okay, there's an asterisk on that. If there's 2 written contracts, so between you and one person or organization, right, business, and they have a contract with someone else and you're performing the services, if there's 2 written contracts, workers' comp applies. I know that's a lot. And you're like, I can do this myself, Amber? Yes, you ask for the contracts. If you were injured from both companies, company 1 to company 2 to you, and that will show that even if you were a subcontractor or 1099, possibly workers' comp can apply to you. So you are considered, this is a legal term, bona fide. If you've seen a Brother Rock down, like he's bona fide, a bona fide independent contractor. Even if there's no two contracts there, if you perform substantial manual labor, so you mix concrete, that's all I can think of right now. But like you are doing physical labor, manual labor. I will say though, truck drivers are excluded from being bona fide independent contractors. That is verbatim. If you look up that statute that's above, it says exclusion, truck drivers. Sorry. But if that is the case, you can go personal injury route, depending. Okay, so who does workers' comp not apply to? Doesn't apply to. These are exceptions, and there's the link at the bottom, the statute at the bottom that you can go to, and you can see all this written out. But in general, workers' comp does not apply to people who are working in a private household. So what does that mean? Maids, gardeners, housekeepers at a private residence, meaning the person who you are going to do work for is an individual who owns that home and they pay you. Okay, this does not mean, if you have a contract with a cleaning company, you are an employee and you are doing you're doing like commercial cleaning. That doesn't matter. This is just individual person to individual person. Unincorporated farms, literally verbatim, unincorporated farms. Real estate agents, but only if you just get paid by commission. Because the alternative is if you get paid like an hourly wage or a salary, then that makes you an employee and you can get comp benefits. But if you just get paid by commission, you don't get comp benefits. Corporate owners, 100% you own the company yourself and you opt out of it. And then this is interesting, especially here in Louisiana. If you are a performer, so like a musician, a dancer, and you're performing under a contract and you get hurt during the performance, the presumption is you don't get comp benefits. Interesting. Okay. Okay. Forms. All the forms that I'm going to talk about today, from a 1008, which is what starts it, a 1010 for medicals, 1020 when you're telling the employer how much you made in a month once you've been injured, all available at lwcc.com. I am going to put that throughout this presentation. You're going to find it at the very end. I'm sure Stephanie is going to hop to the end of this presentation and see the links and probably drop them in the comments. So you can find it, look at it, click on it. It'll be live in perpetuity, live forever on the Facebook video as well. Okay, here we go. All these forms are here. Do not pay for these forms. They are free. Do not get them from any other site. And I should have put any other site. There's another site, laworks.com has these as well. You can get it from there. But if it's people trying to get you to pay, try to put your social security information into a form, don't fall for it. Don't do it. These forms are free. You can even use your phone to fill them in if you need to. Anyway, people love to scam on the internet, and they will. So do not pay for these forms. Because when you just type in Google, if you type in Louisiana 1008 form, they will have some things come up. It's like, .template.com, and they'll ask you to put in your information and pay for the form. The form is free, and they're going to steal your information. So don't do that. Okay. The initial steps, notice of your injury. How do you start a claim if you're injured? What's the process here? You have to report the claim, okay? So the injured worker has to report the claim, and it's different if your employee, and I'm getting into the weeds, but if your employer sees you get hit by a car, a little different there, right? Like there's some circumstances where like if you're not able to report, whatever. But generally speaking, you as the injured worker have to report the claim. It is your duty to report the claim, the injury, mainly the injury, within 30 days of the incident happening. Okay. So if you don't report the claim within 30 days, there's a presumption that your employer can possibly not have to pay you benefits. So if you're injured, tell somebody. You know what? When you're at the airport, if they see something, say something. If you're injured, tell your supervisor. Tell somebody. Tell somebody and get that process rolling. Once your employer knows that you have been injured, okay? There's been an accident, you've been injured at work, you've told them, they have 10 days to file what's called a first report of injury. You may see it sometimes as FROI. If your employer or your HR person does it all the time, they may type that out, but it's first report of injury, it's a specific form. They have to file it within 10 days of being notified by you or someone on your behalf that you've been injured. Okay. Oh, Stephanie already got them links up. Okay. So another form, a very important form. Tubbs is not a grandma. She's just a baby dog. Okay. But this is just like one of the cutest outfits. She used to do therapy work in nursing homes. So like assisted living. I'm sorry. So yeah, it's one of my favorites. But anyway, doctor. So as an injured person, you have the right to choose your physician. Okay. Again, there's a statute. You can go look it up if you want, but I'm just going to get into the weeds with it. So you have the right to pick one treating physician in any field or specialty of the injury. So for example, if you hurt your back, right? And there's, a back injury, there's a knee injury, there's a brain injury, you can choose a physician for your brain, a neurologist. You can choose a physician for your back. The name is escaping me right now. I have not had enough coffee today. What's a back? Orthopedist? I don't remember, but I'm sorry. You're like, Amber, you're an expert. I'm not really an expert because we don't have expert. It's in workers' comp in Louisiana. Whatever, the autism's coming. But anyway, different positions for different specialties, the employee can choose one of them. There is a form for that. Okay. So if you choose a choice of physician if you choose a choice of physician, yes, that's correct. The employer has to pay for that. Has to be reasonable. We're going to talk about defenses to this, but it has to be reasonable. You get to pick who you want to treat you. Okay. You can use the doctor that your employer selected if you like them. It's if you don't like them, you don't have to use them. But if your employer sends you somewhere and you like this doctor, you can use them. You still have to fill out your choice of physician form and you have to sign it. Your employer or the insurance company, whoever's dealing with it, has to send you a choice of physician form. You can sign it and you can pick, you can pick them if you want, but you do have the option to choose whoever you want in your field or specialty. If for some reason there are issues that come up, you never get your form, or, on the employer side, let's say the employee signs the form and then doesn't go to the doctor, doesn't want to go to the doctor after that. What do? You can go in front of an administrative judge. So you're like, Amber, why did you put the word administrative in front of judge? Are you trying to trick me? No. So workers' comp is an administrative law. I'll just say operation matter. So you don't go to your the district court. I live in St. Tammany, so I don't go to the 22nd JDC in Covington, the big courthouse, for a workers' comp matter. There's little, I shouldn't say that, but there are workers' comp specific offices that you go to, and these a judge, sometimes there's more than one, but there's a judge, and the judge hears your matter. You're not on this big long docket with a bunch of other people, but it's small. The goal is that it's supposed to be quicker, right? Because the goal of this is to get the injured worker better and back to work, right? So if there's any issues, you can, what they call litigate this with a workers' comp judge who makes a decision in the matter. Okay. So we talked about choice of physician forms. Another really important form is Form 1010. Okay. This is something that your doctor, not you as the injured worker, your doctor submits on your behalf. So if there is medical treatment or procedures that you need pre-approval from the insurance carrier, and typically it's if something is over $750. I know that's like kind of math, but that's the point. Your doctor knows this. Typically, when you go find your doctor, like your doctors understand this, they will submit this form for you to get that treatment because it has to get pre-approved by the employer's insurance carrier. So the doctor files it. There are medical treatment guidelines based on injuries, whether it's bone or brain or soft tissue, whatever the case may be. You can go read them. They're very long and they're very boring. Sorry if there's any doctors. I respect y'all, but it's a lot. There are guidelines that dictate whether or not an adjuster is likely going to approve the Form 1010. And the adjuster is the person that works for the insurance company, the carrier of workers' comp insurance. So if there's a battle, and I'm not getting too deep into it, but if there's an argument over, the 1010 being approved or not, this could lead to something called an SMO. The employer may ask you, and you have to go do it, to see another doctor, not your treating physician, the one that you picked with your choice of physician form, not that one, but to another doctor. And when you go to this doctor, the second medical opinion, they determine and they make a report about whether or not, I shouldn't say determine, they make a report and they say whether or not they agree with what your doctor is saying treatment needs to be, or if they disagree. And then if they disagree, sometimes what happens is then you go to a third doctor, and this isn't your treating physician. This isn't the employer's treating doctor. So this is the employer's second opinion. This is an independent medical expert from the Office of Workers' Comp. So you've got yours, you've got theirs, and then you've got the Office of Workers' Comp doctor who looks at the reports, looks at the records, and they make a report, and then you go from there. Typically, if there's still issues with it, that's when you litigate or you try the claim in front of a judge. There's depositions, there's discovery, but that's kind of the process of how that happens and what that works with for medical. Okay. So this is important. So I just wanted to give the brief overview of those forms. I kind of got into, I got into, some specific issues that you may run across. medically, I feel like real world examples are really beneficial. So now we're going to talk about average weekly wage. Okay, this is really important. We're talking about more. This is really important in determining whether you are full time or part time if you're an injured worker, and then for businesses determining whether or not they were full or part time, regardless of what you may say in an agreement. Okay, because sometimes folks misclassify on both ends. Okay, so the average weekly wage does involve some math. Okay, but don't be like Tubbs. Don't just ignore me. Don't zone out. Don't zone out. Okay, I make it simple as much as possible. So under this statute, when you're determining your average weekly wage, if you've been hurt or your worker's been hurt, is you look at the 4 full weeks prior to the accident. This is going to include holiday time. It's going to include vacation time. 4 weeks, full weeks there of what your average hours worked and weekly wage was. If you're full time, there's a 40-hour presumption that even if you didn't work a full 40 hours in 1 week, let's say you work 38, you're going to be presumed to have worked 40. It gets a little confusing, but this example is going to show you what that means. Okay, so first example, Timothy Flanders. Let that sit for a minute. Timothy Flanders. Do you know what Timothy Flanders? No, I made that name. You may, but I combined 2 of my very special interests: The Simpsons, right? Flanders, Ned Flanders, and Timothy Chalamet, also known as Paul Atreides from Dune. It's my favorite book, one of my favorite movies. Anyway, Timothy Flanders. He's a chocolate maker. He played Willy Wonka. That's the joke. Okay, so Timothy, he's a chocolate maker. He earns $20 an hour. Okay, in the 4 weeks before his accident, he worked 40 hours, 38 hours, 42 hours, and 40 hours. So we're going to use those hours. He's full time, clearly, right? There's a presumption he's full time. When we do his average weekly wage calculation, we add all the hours that he worked, 40. If you look here, 40, you're like, Amber, it says 38. Well, remember, there's a 40-hour presumption because he's full time. So instead of using just 38 hours, we calculate using 40 hours. So he gets, air quotes, an extra 2 hours, okay? 42 and 40. We add all that up, we divide it by 4, and we find out that on average, old Timothy Flanders worked 40.5 hours a week within the 4 times before, the 4 weeks before he was hurt, okay? So we do 4.5 times 20, his hourly rate, and his average weekly wage is $810 a week. That's a lot. Okay, so Timothy, full-time. So we presume that he works at least 40 hours every week. Now you'll notice that the week that he said he worked 42 hours, we still count actually 42 hours. We don't bump it down to 40. It stays 42. Okay. Okay, now let's talk about Timothy. Timothy did great. He is the king chocolate maker on Arrakis. Way to go, Timothy. Okay, he got promoted. So now, instead of making $20 an hour, Timothy makes $156,000 an hour. He's salary. You go, Timothy. Okay, salary. And I'm sure a lot of you listening to this, or you may be salary as well. Okay, so let's talk about salary. You're not going to go in and do your average weekly wage based on your hours worked because you're not paid before your injury based on the hours you work. You're paid the exact same rate, the exact weekly wage every week, right? Because you get paid a salary the whole year. So what you do instead is you take your salary, Timothy's salary of $156,000, you divide it by the weeks in the year, which is 52, and we find out that Timothy is making bank and he makes $3,000 a week for average weekly wage. Awesome. That's fantastic. He's going to get a whole bunch of money, right? Right? Because he's making $300,000 a week. No. There are limitations. There's minimums and there's maximums. We're going to talk about that when we get to temporary. Total. I get confused. I'm sorry. I'm very smart, y'all. I'm just autistic and I split words sometimes. TTD benefits. I have it written down. Okay, don't hate me. Okay. So I just wanted to get the average weekly wage down before we go into using the average weekly wage to determine how much, if you're injured and you can't work, how much you're going to get a week in wage benefits. Okay. So we did full time, we did salary. Now we're going to look at part-time folks, your average weekly wage. How do you figure that out? Okay. So instead of that presumption of 40 hours worked a week for full time, we are going to look at your actual hours worked in the 4 full weeks, just like the other time, 4 full weeks as well, but right before your injury. So if your employer has records that shows that you accepted a position that customarily, normally, you don't work 40 hours a week, you work less than that. So if there's an agreement, an application, something like that, then you won't be presumed that the full 40 from before with the regular full-time workers. Okay, so here's another example. Buffy Simpson. Again, Simpson. And my other thing is Buffy the Vampire Slayer. Love you, Sarah Michelle. Okay, so Buffy Simpson. Okay, Buffy Simpson works at a boutique. Way to go, Buffy. She earns $15 an hour. So again, we're figuring out her average weekly wage because she's a part-time worker. 4 weeks before her accident, she worked 20 hours, 25 hours, 15 hours, and then another 20. Okay, so we add all that up. That is 80. We divide that by 4. That's the amount of weeks right before the injury. So on average, she works 20 hours a week. So we take 20 hours a week times her average wage per hour, 15, 20 times 15 in 1 week. Buffy makes, on average, $300. She's not like Timothy with his 3,000. She's got 300, but you know what? That puts food on the table. So there are minimum amounts and there are maximum amount limits. Did I go backwards? No, I didn't. Okay, I'm sorry. So part-time employees, retail, seasonal, as long as you're working under 40, right? You are looking for your average weekly wage at actual hours worked. Full-time, you get presumed 40 hours. Presumed, boom, 40, at least 40. Salary, we talked about. Sorry, we don't care about the hours you work. I'm just kidding, but like, you know what I mean? I know it seems like I spent a really long time on this, but it's important. It's really important that you know, and you can figure out average weekly wage if you're injured, or if you are an employer, if you're trying to figure out what the average weekly wage should be for your worker, that you're looking at the right wage statements and the right set of facts. Okay. So let's get into benefits. Okay. Wage benefits and medical benefits if you're injured. on the job in Louisiana. Okay, so I've used this picture of Tubbs a lot. I'm not gonna lie, I just forgot to change it. I'm sorry. I mean, clearly I stuck my head in the bush and forgot to change the picture of her. Here we go. Temporary total disability, TTD. You hear this all the time. You see it everywhere. If you're like me, maybe you flip total and temporary wording sometimes. I'm doing a lot. Okay, so weekly amount that if you're unable to work because of your disability from your accident, you as an injured worker are entitled to. Okay, we got more math, but don't worry, I'll break it down again. TTD benefits are limited to 66.67% of your average weekly wage. See, that's why it was so important. We knew how to do the average weekly wage. So if you were hurt and you cannot work, this is different than if you are working but on light duty. That's going to get into SEB benefits, which we will talk about how to calculate. But this is you were hurt at work. Because you were hurt at work, your disability, and whether it was a new disability or it was aggravated from before you disclosed, whatever the case may be, you can't work. Because you can't work, you are entitled to 66.67% of your average weekly wage from before your injury when you were hurt. There's a minimum and a maximum of TTD benefits. We're gonna go through it, but it's based on the year you were injured. Okay. And there's a formula, there's a statute, the links at the very end here, and what Stephanie put into the comments in our live session will be able to bring you to the chart for that. Okay, we're gonna go back to Buffy. Remember, Buffy's our part-time retail worker. She works at a boutique. She makes $15 an hour. Buffy was hurt January 20th, 2026. She was hurt yesterday. Okay, her average weekly wage that we figured out was $300. When you take 300 and you multiply it by 66.67%, and it's okay if you type it into Google or a calculator to figure it out because I have to do that. You get $200.01. So that would be Buffy's TTD benefits because she can't work. Okay. She was hurt yesterday. It was catastrophic. She can't work. There's paperwork trail everywhere. It says she's disabled. She can't work. She can return in 6 months, 3 months, whatever. But anyway, she's entitled to it. Okay. Just she's entitled to it. Her TTD benefits come up to $200. But as of right now, our state minimum for TTD benefits is $234. Does Buffy only get $200? No, it's a minimum. So if you are a low threshold worker, meaning you make less than that minimum, 234, you will get that. I think I broke up. Okay. So if you only make so Buffy only makes $200 a week. The insurer would just pay her $200, not the 234 minimum. Is that what happens? You're never going to get more than your actual average weekly wages. Okay. But you could receive more than the 66.67% if you were hitting that minimum floor. Okay. Timothy. Let's go back to Timothy. Timothy got his promotion. Timothy makes that $3,000 a week. He's a high earner. He got injured in 2026 as well. His TTD benefits, when we do that calculation of the average weekly wage times 66.67%, or if you move the little decimal over, it would be 0.6667. The formula brings him out to $2,000. That's a lot of money. Way to go, Timothy. He doesn't get $2,000. Why does he not get $2,000? Because he's capped. Now we had a minimum amount and we had a maximum amount for TTD benefits in Louisiana. And as of right now, the maximum is $877 a week. So Timothy, being a high wage earner, he's not going to be getting that $2,000. He's only getting $877. That's the flip side here, the minimum and the maximum for TTD benefits. Okay. Now, let's say you're injured. You can work though. It may just be at light duty, or maybe it's less hours, or maybe you're working and you're getting paid less than you were before. Maybe you're not working at your old employer. Maybe you're working somewhere else because they didn't have a job for you. You don't get TTD at that point because you can work, but you get what's called SEB, Supplemental Earnings Benefit. Okay. There's a statute. You can look it up. You were released to work, but it's at a lighter duty, lower rate. We have to do more math. You qualify for supplemental earnings benefit if you meet a threshold of earning under 90% of your average weekly wage. Again, I told you average weekly wage is really important. And then we're going to go through a calculation, but I'm just giving you the overview here. You have to file a Form 1020 every month and report your earnings to your employer, or these benefits may stop. That's really important. Okay. If you're the injured worker, if you're the business, making sure that folks are giving you the 1020s. Okay. So let's do some math here again. I know this is terrible. I tried to make it as easy as possible, but it's just did my best. Okay. So what are we going to do to figure out your supplemental earnings benefit? So again, you're injured. You can work, but you're just working at either a lower rate, less hours because of the injury, not just because you don't want to, okay? Because of the injury, and it's documented, right? You're going to take your average weekly wage. You're going to subtract your post-injury earnings, so what you're making at the new job or the less hours, whatever the case may be. You're going to get an amount. Then you're going to multiply that by 66.67%, and that's going to be what we look at for the threshold here, okay? So Tubbs' average weekly wage, she's a hard worker. She sleeps all day, but she's a hard worker. Her average weekly wage was $1,000. 90% of that is $900. So if she makes less than $900, she's entitled to supplemental earnings benefit. That's the threshold. If she makes less, let's say Tubbs is on light duty. She's still working at her old employer's place, but she can't work as much as she used to. So she only makes $600 instead of $1,000. Okay, 600 is beneath her threshold of 900. Okay, so remember, she made 1,000. That was her average weekly wage. If she makes less than 90% of that, which is 900, she's entitled to supplemental earnings benefits, and she does. So now you do more math. Okay, you take the $1,000. That was Tubbs' average weekly wage. You subtract what she's earning post-injury every month, $600. Well, every month, every week there. It's $400. We take 400 We multiply it by that fancy percentage, 66.67, and that comes out to $266.68. So that is the amount that gets paid to Tubbs if she submits her 1020s and she continues to make less than 90% of her average weekly wage from pre-injury. Okay. So she gets an additional $266.68 to make up that difference. She was making she was making 1,000 pre-injury. She's making less. We did all our math. The difference there is about $267. So her benefit is $267. Okay. Medical benefits. We got 12 minutes. We're still on track. Don't freak out. Don't be like, oh my gosh, we haven't gotten to it. It's easy peasy. Okay. We're gonna get through this together. Okay. Medical benefits. You are entitled, if you're an injured worker, to reasonable and necessary medical treatment that happened because of the injury that happened at work. Okay. Medical benefits 101. There's some statutes here that you're going to use. We got Dr. Tubbs here. Your employer, the insurance carrier, has to pay for reasonable and necessary medical care. There's a $750 cap for non-emergency procedures and diagnostics. Okay. So diagnostics is like blood work, testing, that's all I can think of right now. Adjustments. $750. Anything over that requires authorization. And remember, what form is that? 1010. 1010. Your medical provider will file a 1010 if they need pre-authorization for anything that's over $750 for your treatment. That's reasonable and necessary. So sometimes there is issues with whether, we kind of talked about this before, the 1010s, whether it's reasonable and necessary, whatever the case may be, and there may be arguments from either side that treatment is not necessary. And then we get into something where there's a Form 1009 filed, where they're controverting it. A medical director will weigh in to determine whether or not, this needs to be paid out. But in the event, this is really important. If you have a doctor, you need to make sure that they know. And it's usually why when you do your intake forms when you go to doctors, it says, is this a workers' comp case? So they know to file these things. It's a little bit different than just your normal healthcare provider. I'm sorry, your normal insurance company, right? When it's a workers' comp issue. If a 1010 is not submitted by your doctor and they do the procedure, whatever it is, and they don't get pre-authorization, then your insurance carrier for workers' comp capped. It means their maximum liability that they're going to pay for it is $750. That's it. And that's by statute. So make sure if you have a medical provider, your choice of physician, whoever you've selected, they know about this and they're filing it. Okay. Also, with medical benefits comes mileage. So if you are hurt and you have to go see a specialist, physical therapist, chiropractor, pharmacy to pick up a prescription, anything like that, you are entitled for reimbursement for mileage to get there and to get your treatment. The mileage rate that you're going to use is based on the time that you go get that treatment, not when you were injured. So we talked about before about a minimum and a maximum threshold for TTD benefits, and that's based on when you were injured. But for mileage, for your treatment, it doesn't matter. When you were injured, if you were injured in 2012, we're not going to be using 2012 federal mileage rate. We're going to be using 2026. So right now, as of today's presentation, that mileage rate is 0.725 or 0.73. The claimant, meaning the person that's injured, has to submit mileage for reimbursement. There is no form. There's no form on the internet for that. Typically, the insurance carrier will provide you a form just so you can keep track. If you have an attorney, they'll provide you a form. It doesn't have to be anything fancy. Point A to point B, date, miles, boom. And you don't even have to do the math. I'm just kidding. You may want to do the math to make sure you're getting paid the right amount. But once you submit it, it must be paid within 60 days. So it's up to the person who's injured or someone on their behalf to submit mileage every month. And then once it's submitted, the insurance carrier or the employer has 2 months, 60 days to pay it out. Okay. So we talked about insurance. We talked about injured workers a lot, but I do want to talk about how companies or small businesses can defend claims that are worthy of that. So now we're going to talk about when that happens. This is called affirmative defenses, right? It says someone says they got hurt. Okay. I'm saying I don't have to pay because of these reasons. Okay. I shouldn't have to pay these benefits because of these reasons. Okay. Just because workers' comp is no fault, you don't have to really prove fault. It doesn't mean that every single circumstance you're going to get benefits. And here are some things that will not get you benefits, medical or wage or otherwise. Willful intent. If you try to hurt yourself on the job, you're not gonna get on purpose. Okay. If you get into a fight at work, but you were the initial aggressor, it's not self-defense, and that's a whole other issue. But if you get into a fight at work, whether it's with an employer, an employee, a coworker, a customer, if you started, you likely aren't gonna get benefits. Intoxication. Now, this is a big asterisk next to it. Okay. Intoxication doesn't just mean alcohol; it also means substances, prescribed and not prescribed, and you have to use prescription medication. There's you can get into the weeds on this one. But I do want to point out that if your employer has a substance abuse policy, and it's written, okay, typically you'll get this when you're hired or throughout the process of working there, you do not take a drug test or an alcohol test when asked after the accident. You will be presumed to be intoxicated. Now, there's still things that you can argue about. You can still say, produce evidence that I wasn't, or whatever the case may be, or maybe I took something at home and it didn't affect me at the job. That's down the road. But for immediate actions, you're going to be presumed to have a positive drug test or a positive alcohol test if you don't take it, and there's a written substance abuse policy. Now, even if the person, the injured worker, is intoxicated, you still, as an employer, have to provide emergency medical care. You still have to do that, get into the weeds later, but you still have to provide that immediate emergency care. A big one, and I do want to stress this, is fraud. Okay, Tubbs is in her jumpsuit here. Okay, it's unlawful for any person to willfully make a false statement or representation for the purpose of obtaining or defeating. So obtaining or defeating means injured worker and employer. Okay, it goes both ways. Any benefit or payment. This is fraud. So this typically you'll see this if someone says they were injured at work and they want to get benefits, TTD, SEB, medical benefits, but come to find out they really weren't injured at work. They were injured, at home 3 days before. Or, in order to get hired, you say that you never had any injuries on your questionnaire, and it come to find out that you had, 3 back surgeries, an ankle surgery, and a foot surgery. It has to be a willful false statement. Just saying if you were in a deposition or something. That's where a lawyer's asking you questions because y'all are fighting or arguing over an issue. And let's say they ask you, have you ever hurt your foot before? And you say no. And then you come to find out, 20 years ago, you stubbed your toe or something in a medical record. That's not the same. That's not the same. Okay. You have to be really egregious in making the false statement. But it does happen. Or another example is, you say you can't walk or stand up for more than 10 minutes. And, there's surveillance video of you playing pickleball for 2 hours. Things like that. There's a medical questionnaire. If your employer provides that to you, or if you're a business, I'll listen up. You should be providing this. There is a form at the very end here that you can use from LA Works and LWCC. If someone says that they had a pre-existing injury and they disclose it at the time of hire, and they get hurt later and it aggravates that injury, you possibly can get reimbursed for those benefits from what's called the second injury fund. So it's important to know as employers, and then also employees, please be truthful. You have to be truthful, not just forgetting, but we've seen some things. Okay, fraud, penalties for fraud. There's criminal penalties to this, okay? It's not just because it is, I'm not saying just because, but I said that there's specialized administrative courts for workers' comp. There are serious consequences if the employer or the injured worker or a doctor, anyone involved, is making willful misrepresentations to court for the purposes of getting these benefits, okay? It depends on the amount of benefits you were the recipient of. So there can be a fine anywhere between $500 to, up to $10,000 or more. Jail time, that's a real thing too. 6 months up to 10 years for fraud for workers' comp. That's you don't want that. And then of course restitution, where you have to pay back any of the benefits that you were paid. Okay, that's a lot. I don't want that. All right, so resources, types of different resources. Here's all the links, which Stephanie did put into the comment section, okay? So you'll be able to see this, lwcc.com, laworks.net for forms and resources for both injured workers and businesses, okay, employers. I did have a list of all of the places in the OWC, the Office of Workers' Comp districts. So if you need to file your forms, you'll know where to go, who to call, things like that. And then, of course, there's a list of downloadable forms as well. So this is where I asked for questions, but I know I went over just a little bit because we had a tech issue thanks to moi. So if you have any questions, type them in the chat or on Facebook and they'll relay it to me.
Perfect. Thank you so much, Amber. We're not taking any questions at this time, but feel free to post any questions you have in the Q&A section on Zoom or in the comment section on Facebook. While we wait for questions, I want to highlight some additional resources. These may be helpful to you if you have a legal question that was not addressed during this presentation or you need help getting assistance. This is a flyer for the LSBA's Find Legal Help page where you can access a continuum of services. It includes our attorney directory, the Civil Legal Navigator, legal aid and pro bono organizations, modest means directory, and self-help services. I like to call special attention to Louisiana Civil Legal Navigator. This is a great sort of diagnostic tool that helps you identify your legal issue and provides customized information, referrals to legal aid, and more. It is simple to use and will give you the next steps specific to your issue and or your parish or location. You can also access Free Legal Answers, which is an online pro bono program that allows users to log in whenever and wherever they like and ask civil legal questions and have attorneys answer those questions through the site. It is private and it acts almost like an email exchange between the user and the attorney. Please note that the users must meet certain income guidelines to use this program. Okay, so let's see, we do have some questions popping up.
We do. Unfortunately, one of them is very specific, and so I can't answer the very specific question. But as far as I can answer a general question of, is it worth getting workers' comp coverage? Yes, and it is statutory. So I think for that person, you should seek legal advice from a particular attorney, which you can do with these resources that Emily just mentioned. A good example would be Free Legal Answers, la.freelegalanswers.org, la.freelegalanswers.org, with that specific question, and they can answer that specifically. I just can't on this. Yes, and statutory means it's in the law. So all those little LARS things that I put throughout this presentation, that's a statute. And so if it's in the statute, if it's in the code, if it's written down, it's a law. Let's see. Someone else asked for tips for any clients. I don't really understand this question.
Do you have any tips for a practitioner who's working with undocumented clients who have workers' comp claims?
Okay, thank you, thank you.
No problem.
Again, that's very specific. I would leave that to a panel, and this sounds terrible, but a panel of an immigration attorney that you trust to discuss with a business attorney at the same time. I say business attorney because typically if it's an undocumented worker, even if it's workers' comp, related, there's some other issues as well. So I think it's best that you have a tandem working relationship with those folks because they feed into each other, and it's not something that I can answer on here. I wish I could. I'm sorry.
No worries. Okay, I'll leave another couple seconds for any last minute questions before we conclude.
And there is, Stephanie put it, no, Stephanie, can you put, oh, you did, okay. Workplace Justice Center. It's in the comments, but just for prosperity's sake, it is www.wjpnola.org, and it's Workplace Justice Center, wjpnola.org. That's a good resource for folks that have undocumented or need some more specifics on some areas that we didn't touch on today for comp.
Yeah. Okay, I don't see any other questions coming in. So we're going to go ahead and conclude our Law Talk workshop for today. Please save the date for our next Law Talk. which is going to be February 24th at 5:30, and it's going to be a divorce lawyer's guide to getting married smart. Thank you so much, Amber. This was fantastic. Very useful, very important information to share. We always appreciate the time you are able to give us on these law talks. So thank you so much. Thank you to everybody who joined us today. Yes, of course, thank you to Tubbs for also being in the presentation. And we hope you'll have a wonderful rest of your day.